A federal judge is expected to issue a written ruling today in a high-stakes lawsuit accusing ICE and Border Patrol of breaking the law during immigration raids in Southern California. Plaintiffs, including the ACLU, Public Counsel, and at least 6 cities like Los Angeles, allege that federal agents have been racially profiling people, denying detainees access to attorneys, and ignoring due process rights. At the heart of the case is video evidence from a controversial raid at a studio where a man says he was stopped simply because of his skin color. They are not respecting the Constitution, the man told reporters. In court, the plaintiffs argued that federal agents have been sweeping up individuals not based on any sort of information, not based on any reasonable suspicion, calling the tactics illegal and discriminatory. But federal officials strongly deny those claims. Bill ACLU, U.S. Attorney for the Central District of California, said, *, these are administrative cases. People are not being arrested because of skin color. Every arrest is based on individualized suspicion. *. One key issue is that the detention facility in question was closed to lawyers for 2 weeks during the raids. Plaintiffs argue that detainees were denied due process and legal representation, which is protected under U.S. law regardless of immigration status. ICE officials counter that during the massive operation, which at one point surrounded a building with hundreds of thousands of people, they had to temporarily close the facility and restrict attorney access for safety and logistical reasons. Critics have also pointed to how the Trump administration previously handled deportations, defying lower court rulings in cases like Arrigo Garcia, whose plane was ordered turned around mid-flight by a judge after it departed for El Salvador. Constitutional law professor Jessica Levinson noted that such aggressive tactics and appeals show an administration willing to defy the judiciary. In response to losses in court, the administration is going very aggressively to the Supreme Court, asking for emergency relief, she said. Federal attorneys have said they will appeal if necessary. *, we will exercise our appeal when appropriate and take it to a higher court. *. Today's written ruling will follow a tentative opinion already issued by the judge, which signaled support for the plaintiffs. Such tentative opinions, though unusual in federal court, give both sides a roadmap before final arguments. We'll keep you updated as the judge's final decision comes down. To follow this case, and other critical stories about civil rights, immigration, and the law, don't forget to like, share, and subscribe to California Uncovered. Stay informed. Stay engaged.